I have a particular interpretation of IHL, which is quite protective of civilians and other vulnerable individuals. But if you look historically, IHL has not always had that quality. So even after the first four Geneva Conventions, there was little treaty regulation of the conduct of hostilities. Would we really want to say that in armed conflict, human rights law, therefore, does not protect people from the effects of hostilities? Fast forward to the late 1970s with the additional protocols, we have a very different set of rules in international armed conflict and non-international armed conflict. Should a human rights court really say that your human right to life has a fundamentally different content depending on the classification of the conflict in which you happen to be caught up? Would it really make sense for a human rights court at that time to say that your human right to life does not protect you from being used as a human shield, or does not protect you from unnecessary or disproportionate incidental harm? I don't think so. Now, today, we think those rules have largely converged, and many of us have a very protective interpretation of IHL. But I think from the perspective of a human rights court, they should always make their own determination of whether this other body of law adequately protects human rights, because that is their mandate, protecting human rights. So I think they always need to make that separate assessment. The answer might be yes, the answer might be no, but the court always has to ask that question for itself.